Okay, well, this is big. Things are really heating up at the Supreme Court of Virginia. They just dropped a one-sentence decision that is sure to ruin the day of every Democrat in Virginia, maybe nationally, particularly the odious Attorney General, Jay Jones. His day is ruined here in the Commonwealth. On today's episode, I'm going to tell you about SCOVA's Tuesday ruling, what it means for last week's referendum vote on gerrymandering, and what it could be telling us about how the court is going to rule on the legality of that referendum. Hi, everybody. I am Terry. I'm a fed-up Gen Xer and a ticked-off Virginian who's worked behind the scenes in conservative media for years and decided that right now is the time to get in front of the camera and talk to you about the truth. So, welcome to Smart Girl Politics. On our last episode, I covered the oral arguments that took place Monday in front of the Supreme Court of Virginia. Now, if you'll recall, Team Gerrymander, and that's the side represented by the aforementioned very odious Jay Jones, who actually didn't do the arguing and instead outsourced that to outside counsel from California. Now, they argued that Democrats followed the correct process to get the referendum before voters in last week's special election, despite there being ample evidence to the contrary. Now, Team Virginia, Team Freedom, Team Don't Gerrymander the Map, they provided some of that ample evidence, and including one thing that they noted, that it was funny how the Democrats for decades have been pushing early voting. But now they're saying, no, it's really just that one day in November that matters. Interesting. So it might be good to do a little rewind and talk about what happened with the oral arguments on Monday. And who better to do that than our friend Nick Minock? As I always say, if you're not following Nick and you are interested in what's going on in Virginia, get over there, get on Twitter, get on whatever. He's all over the place. Follow Nick.
Thank you. This gerrymandered congressional district map that Virginia voters narrowly approved last week is facing a slew of legal challenges. The Virginia Supreme Court heard arguments today in what may be the most significant of those efforts, deciding whether Democratic lawmakers followed the rules for getting a constitutional amendment on the ballot. Our Nick Minock was in the courtroom and joins us with more now from Richmond.
The main issue the Virginia Supreme Court focused on was one of timing. When Democrats in the General Assembly passed the redistricting referendum, early voting was well underway for the 2025 election, which could violate constitutional requirements. Democratic lawmakers passed the redistricting referendum just days before Election Day 2025. The Virginia Constitution requires lawmakers to pass the referendum once before a general election takes place, then again after the newly elected assembly is seated. Opponents of redistricting argue that since early voting in the 2025 election had been going on for over a month, the referendum did not pass before an election as required. During oral arguments Monday morning, Justice Wesley Russell peppered the Democrats' attorney with questions.
So your position requires us to interpret election in such a manner that literally every single vote that is cast for whatever the office is cast before the election even begins.
Yes, Your Honor, and that's consistent both with the way the federal government has consistently interpreted this, the federal courts, and sister states.
In all, these arguments before the court lasted just under an hour. Until this issue is resolved, Virginia is unable to certify last week's election result. If the redistricting referendum is allowed to stand, Virginia would go from one of the most balanced congressional.
So I'm going to stop the video right there, but I did want to share this one tweet that kind of puts it into perspective how many votes actually had been already cast before the Democrats decided in late October of last year to shove this referendum through. Let's go right back here. Look at this. Look at that. And it's October 31st, as Ken Cuccinelli has told us, that's when they decided that they were going to cram this through. Just a mere few days before, like a week before the election. That many votes had been already cast. And they now they're saying, well, no, but it's kind of like what actually happened on November 7th. It's a bit of a mess. So What happened on Tuesday? We have a wonderful explainer from Delegate Ren Williams, who represents a red part of the state. He is in, I believe, southwest Virginia, and he's a lawyer, he's a delegate, he's got a really good handle on this. So let's tell you what happened yesterday in the Supreme Court of Virginia. The Supreme Court of Virginia has denied the Attorney General, Jay Jones's, motion for emergency stay in RNC versus Cuccinelli, the one where he didn't quote the ballot language. One sentence, no dissent, no partial relief. Upon consideration whereof, the court denies the motion. What this means in plain terms: Jay Jones's outside counsel from California asked the court to allow the election process to proceed pending the rulings on the merits of the gerrymandering case. The court said no. This stops the election from being certified for now. The same Supreme Court that allowed the referendum to go forward in March so voters could be heard has now declined to override a final judgment, finding the constitutional amendment process defective. Strong signal that process matters in Virginia. That's important. The Attorney General asked the Court of Virginia to set aside a final order that exposed a ballot question he would not quote, an Article 12 timeline he had to redefine, and a 1912 case that did not say what he needed it to say. The Supreme Court said no. The merits appeal continues. I will keep you posted as this develops. Ren Williams quickly followed up that wonderful explainer. This one. Basically, Jones asked the Supreme Court of Virginia to allow the election process to go forward while we litigate. He asked to lift the April 22nd Tazewell injunction attached, I will put a link to my interview with former Attorney General Ken Cuccinelli, where he explains the Tazewell decision. This is the crushing order that barred certification of the election and declared it unconstitutional from the start, even found ballot language shameful. Today, though, the Supreme Court of Virginia simply denied the Jones motion, and the underlying April 22nd Tazewell injunction barring the certification of the election stands and remains in full effect. Now Dems are left with their appeal to SCOVA and a special election that's stopped dead in its tracks. So, to put it in a one little brief way of saying it, Jay Jones wants to certify the election right now, and Supreme Court said no. Shut down. Absolutely not. That's really big. That is a good signal, like Ren Williams said, that the process is what's at stake here. The process through which the Democrats trampled the Constitution, they're taking it very seriously. Now, I love a little bit of Ken Cuccinelli explaining things, and he went on Scott Jenks. I mean, wow. Double whammy right there. Two of my absolute favorites. And he's going to explain in only the way that Ken Cuccinelli can explain, because Ken is a former Attorney General of Virginia, but also a former state senator.
We go
so
over to
let's
Virginia.
listen.
We've been covering the new congressional map in Virginia and the legal case to get it thrown out. And we have some breaking news on that. Joining us to discuss, the former Attorney General of Virginia, Ken Cuccinelli. Ken, the Virginia Supreme Court today, as I understand it, has denied the emergency request to stay the injunction of certification of last week's referendum. Explain to our listeners in lay terms what this means for the people who want to get this thing thrown out.
So, Scott, last week, a judge enjoined counting the votes and certifying the referendum. And in the normal course of things, that case is up on appeal to the Virginia Supreme Court. In the normal course, they would stay that injunction and just let the election machinery go forward. Well, today, one day after the oral argument on the earlier referendum case that you and I talked about yesterday, they have denied that simple request from Democrat Attorney General Jay Jones. And what that signals to me is that they already have the votes to reject the referendum as being unconstitutional. They don't care about the maps, but the process by which the Democrat General Assembly brought it about was egregiously unconstitutional. And they have the votes already, and they're just writing the opinion. That's how I interpret today's ruling. And I would add, Scott, back in February, when the Virginia Supreme Court held the first case, the one that they heard oral argument on yesterday, a lot of people thought they were ducking, but they were complying with 100 years of precedent that says the courts don't act until after a vote in a referendum. And at that time, they said, we have very grave concerns about the serious issues raised in this case. And that may not sound like much to non-lawyers, but that is incredibly uncommon for a court to comment on the substance of a case that it was holding in place. And I think that they were setting expectations even back then that this looked too brazen to survive. And I take today's second signal, and these are just tea leaves, in the same direction. I think this thing is going to get thrown out, and I think it's going to be thrown out pretty quickly.
Let's just remind our listeners what's going on here. The Virginia Democrats decided to have a referendum on redrawing the state's congressional map. Currently, Virginia has 6 Democrats and 5 Republicans, 6-5, and it is a purple state. It's about a 50-50 state, slight tilt to the Democrats. So the congressional maps currently actually are some of the most balanced and well-drawn maps in the country. It was done by an independent commission. Democrats have a referendum. They narrowly pass a new map, and that would go from 6-5 to 10 Democrats to just 1 Republican. So now we're in court. The Virginia Supreme Court is the last stop on whether this map will go into effect. Our guest today is Ken Cuccinelli, former Attorney General from Virginia. Ken, I have to say, you've been very consistent from the beginning of this. You've told us here on the show that you don't expect this map to survive the legal challenges because of the procedural issues. Final question for you today. Tell us about, I've got 30 seconds. Tell us about the Virginia Supreme Court. Is it considered to be liberal, conservative, or more nonpartisan?
So it is considered to be among the more nonpartisan state Supreme Courts, but of the 7 justices, 4 were selected by Republican General Assemblies and 3 were selected by Democrat General Assemblies. So it's pretty balanced, but I would not be surprised, Scott, to see a 7-0 ruling against the referendum here. That's how egregious the General Assembly was. And of course, I've told you that before. I told you that last week, right, when I was on Friday. And I think we may be headed in that direction.
Ken Cuccinelli, thanks for the update. We'll be hearing back from you shortly, it sounds like, when we see what happens.
Something I do appreciate about Ken Cuccinelli's take on all of this, other than that he's got a very unique one, is he addresses that the Supreme Court of Virginia heard this case first back in February and decided to let the referendum go ahead. Now, I took that as a non-legal, just a regular Virginia citizen. I took that to mean that they were going to let it stand, because it's very hard to think that they're going to let all of Virginia go to the polls, vote, and decide on something. And despite the fact I don't like the way that they decided it, that they were going to then overturn the will of the voters. Now, what was pointed out during the oral arguments by many is that a couple of the justices did quiz them on that. And it was established very, very, very early on. And even Team Gerrymander had to admit it, that the result of last week's referendum has no bearing on the case in front of the Supreme Court. It is the process by which the Democrats got the referendum onto the ballot. It's the process by which they were able to get the referendum and the special election set up. They broke all the laws. They broke them all. And Ken Cuccinelli thinks that that is what SCOVA is indicating. So for now, it cannot go forward. Jay Jones's hands are tied on this one legally. And there are a couple deadlines coming up. I believe they wanted to certify the election by early May. There's a lot of things that have to happen. There's primaries and blah, blah, blah for all these new garbage districts that the Democrats have created. So he can't do anything right now. This is why we do not care for Jay Jones. He's bad. He's a bad man. He's an elitist. He's a snob. He doesn't know what he's doing. He's completely unqualified to be in this position, as evidenced by the fact that he could not present the oral arguments before the Supreme Court of Virginia the other day. So, but he's just a goof. He's just a goofy dude. So let's take a look. Such a goober, right? He's a massive doofus. So anyway, he's tied. His hands are tied right now. He has got to wait for the Supreme Court of Virginia to decide what's going to happen, whether this referendum stays or whether it gets thrown out. So before I let you go, if you like what you see here, be sure to subscribe, like, share, always drop me a comment. What do you think of Jay Jones? Because I think he's just the biggest disaster that Virginia's seen since, say, Abigail Spanberger. And if you need to catch up on where things stand with the gerrymandering case currently going through the Supreme Court of Virginia, I got a video for you right here. So I'm going to let y'all go. Bye, friends. Always be safe out there, okay? I'll see you next time.